I'm Drew Stevenson. This is for my administrative law class. Here I'm going to be talking about something called the Public Rights Doctrine, or the distinction between public rights and private rights. This will help you understand some of the cases that we're going to study in our casebook in this unit. So let's dive in. So to start off, keep in mind that Article 3 of the United States Constitution appears to vest judicial authority in the courts, which we often call Article 3 courts. Some have argued that it violates this provision of the Constitution for executive branch agencies or independent agencies to adjudicate cases because the Constitution seems to vest judicial authority in the courts. As one law professor observed in an article in 2020, there's a longstanding practice, sometimes reaching all the way back to the founding of Congress, giving adjudicative authority to decision makers outside the federal courts who lack Article 3's independence protections. These decision makers include territorial, tribal, military, and other so-called Article 1 or legislative courts, as well as administrative agencies. In our course, we're more focused on the last of these, on administrative agencies. Please note that the law in this area has become voluminous and complex, but there were many decades where there were very few challenges to this type of arrangement on constitutional grounds. Over time, the United States Supreme Court has permitted more adjudication by or within administrative agencies and or by non-Article 3 courts like bankruptcy courts. As your casebook authors note, for over a century, the federal courts seem to have been more concerned with preventing judges from becoming involved in administrative adjudication than in preventing administrators from adjudicating legal claims. That concern was voiced early in Haburn's case in 1792, which involved a circuit court determination of veterans' benefits claims that were subject to review and revision by the Secretary of War. More broadly, the Supreme Court was long doubtful that the courts would be given jurisdiction to exercise appellate review of administrative adjudications. And there's a number of cases about this from the 1850s. The court did not approve a statute providing for appellate review of administrative adjudication until 1899 in United States v. Duell, a U.S. Supreme Court case. Now, I do want you to keep in mind that executive agencies and officials have been authorized by Congress through statute to adjudicate what we call public rights throughout our country's whole history, right? So that they've done this all along. And the courts have always readily accepted agency adjudication of public rights. But it's a different story when the agency is adjudicating a private right, in other words, something that looks more like a traditional common law legal dispute, and that they treat these with more caution or suspicion and scrutiny. And historically, agencies could always adjudicate public rights cases that are under their statutory purview or jurisdiction, but only in the last 100 years or so have they begun to adjudicate some private rights claims. Historically, or traditionally, public rights are claims against the government, or in some limited cases, claims by the government against a private party, and territorial claims and military cases. Private rights, in contrast, are legal disputes between private parties. These are the traditional common law areas of torts, contracts, or property claims and disputes. Also keep in mind that private rights claims adjudicated by agencies have to leave enforcement to the regular courts and not tread on any other traditional court functions like criminal penalties or holding jury trials. The real turning point in this area was a case called Crowell v. Benson in 1932. And that's the first case where the Supreme Court approved sort of expressly adjudication of private rights by an agency. And this case involved sort of something analogous to a workers' comp type claim by longshoremen. These are dock workers who had been injured against their employer. And Congress, by statute, had assigned longshoremen's claims to a commission called the U.S. Employees Compensation Commission. In the late 19th and early 20th century, state governments created workers' compensation programs to provide support for employees who had been injured in the workplace. And these programs, which were created by statute on the state level, operated as an alternative to the traditional tort system for personal injury claims, which wasn't working very well to protect workers at the time, especially with the advent of modern factories. But no state program could really reach dock and maritime workers because of the federal government's exclusive maritime jurisdiction. So in 1927, Congress addressed this gap by enacting the Longshore and Harbor Workers' Compensation Act, which basically became the statute at issue that was being challenged in Crowell v. Benson. Now, in Crowell v. Benson, the Supreme Court relied heavily on the fact that there was still judicial review available under the statute, and that was part of why they upheld this statutory scheme. And that de novo review is going to be for questions of law and questions of jurisdictional fact in the cases. On the other hand, they are allowed to, the courts are allowed to defer to an agency's fact-finding, right? Because the agency, when they held their hearing, it's easier for the person who adjudicates the claim to make determinations about the credibility of witnesses and so forth, right? You get to see it firsthand, the arguments and the questioning and people's responses, and decide which side is more credible or more believable. So where does this leave us? Agencies may adjudicate private rights disputes, but only in cases that are closely related to a public rights claim or dispute or action, like a counterclaim in an agency action. And there has to be judicial review available, and that has to include de novo review of questions of law and questions of jurisdictional fact. And that concludes kind of my brief introduction to Public Rights Doctrine, or the difference between public rights and private rights.